So I had a couple of points to offer, not necessarily on the question being asked. So if anybody else has commentary on that question, I'd happily step aside and let that dialogue finish. But the same way that folks have been offering suggestions and policy ideas, I have a couple on my behalf. And I just want to make.
Yeah, please proceed.
So two specific ideas that I want to put forward. I know that a lot of this debate seems to be falling into either one of two buckets. Either you are proposing things that are pro-management on the police side, or the police chiefs, or pro-union, the individual police officers. And really my experience as a civilian, as an attorney, public defender, and now with Para, I think that there is an element of the conversation that's missing, that is the civilian perspective. And so two specific policy ideas that I would put forward, and I hope that this board takes into the consideration, and as well as leaders at the State House. New York State passed a statute this summer, or better stated, repealed a statute this summer known as 50A. And we have an equivalent of that in Rhode Island under the Access to Public Records Act, which is a subparagraph, and I have the site here, that basically says, the Access to Public Records Act, in essence, says everything is a public record except, and it lists all these subparagraphs taking things out. One of those subparagraphs talks about police records, internal police records. And so what New York State did was repeal that provision of the law. And that was their response to the George Floyd killing, which took place. I mean, they did that within 2 weeks, which is one of the points I was making at one of our previous meetings, that we have, it's great to have the opportunity to engage in this dialogue, and I'm grateful for it. At the same time, we should be mindful of the precedent that's been set across the country, and states moving on this issue with the sort of urgency that it deserves. So taking a step like that, repealing that provision of the Access to Public Records Act, could go a long way towards solving some of the legal hurdles that we were talking about here. And with regard to the particular law enforcement officers' Bill of Rights, there are provisions, in addition to everything that everybody has said, whether it's regard to 2-day maximum or some of the other points of transparency that Mayor Elorza mentioned. Obviously, we agree with a lot of those. There's also something to be said for the particular portion of the Law Enforcement Bill of Rights that governs the actual investigation of the police officer. And I'll give you one specific example. Under the law, a police officer who is subject to investigations by the police department has to be given not only notice of who it is that's going to interview them. It can only be one person from that department that interviews them. And they also have to be given a narrative, if you will, of the complaint before they speak. Now, on the one hand, I'm sure there's points of that are in line with current law, but you have to understand that when there's any sort of accusation of wrongdoing, the status quo of the Leo board right now is very different from if you were to sit somebody down and simply ask them what's going on or what happened in this situation. I remember specific points in my life, obviously nothing like law enforcement investigation, but some sort of organization in college or anything else, and somebody accuses you of something, and I got sat down and they just asked me, so tell me what happened, which goes a lot further towards truth finding and fact finding than if you get the opportunity to review the accusation against you in advance. So there's a number of provisions in the Bill of Rights that go against fact finding. I think we can do a lot of justice by either reforming or repealing those provisions as well. And the last point that I would make is the conflict that exists between the Leo board and what is constitutional law, right? Not to get too much into the weeds, but there's this idea in the Constitution that federal law will, if there's ever a conflict between federal law and state law, federal law kind of rules the day because it's the supreme law, if you will, it's the more precedent. And when we're talking about civil rights or the sorts of violations that people are bringing forward to places like PARA, the Internal Affairs Bureau, et cetera, we're talking about folks who've been deprived of their Fourth Amendment rights, or at least that's the accusation, right? I was injured, I was hurt, I was searched when I shouldn't have been. I'm being deprived of my Fourth Amendment rights, my Fifth Amendment rights, et cetera. And what you're seeing in effect is Leo Bohr kind of getting in the way to the path of justice in that sense, right? And so either way you cut it, there seems to be a conflict between what are the civilian rights, Fourth Amendment, Fifth Amendment, you can't search my car without a warrant, and what the Leo Bohr does. And to the extent that there is a conflict, it shouldn't be the state law that's ruling the day. It should be, our focus and our emphasis should be on the civil rights of civilians, because that's what these laws ultimately are meant to protect. I think that the Leo Board is something that originated as a good idea. The origin of it comes from two U.S. Supreme Court cases in the 60s. Obviously, we did a little bit of that in the first panel, but I think over the course of time, like many other laws and many other examples, it's kind of grown into something that it wasn't originally supposed to be. And so when we're looking at reforming the statute, I think that those two ideas will go a long way towards solving some of the challenges we talked about in this meeting.
Well, thank you. Thank you.